Please be seated. The court is now back in session. And again, we would like to hand the floor to Noon Chief Defense to continue presenting their closing statements. You may proceed.
Thank you, Mr. President. Your Honours, I would now like to turn to the documentary evidence supplied by the prosecutors. And also, this evidence proves nothing of any substance. On 8 July of this year, we established, during our response to the co-prosecutor's key document presentation, that the documentary evidence relied upon by the co-prosecutors in regard to the existence of an alleged policy of executing Lon Nol soldiers was systematically irrelevant and unreliable. The co-prosecutors have presented no new documentary evidence, either in their final trial brief or in their oral argument. Therefore, in general, I would like to refer the Chamber to our submissions from that day in regard to the prosecution's documentary evidence. However, I will reiterate our submissions with regard to two of those documents, because the co-prosecutors relied on them frequently again this past week. First document is E3/832. It is entitled Execution Order. And it is dated July 1975. And it lists 17 names and purports to originate from a soldier named Comrade Pin. All this document shows is that an order was delivered by Comrade Pin to somebody to execute 17 specific people. It does not show who the order came from or to whom it was delivered. The fact that the order ostensibly came from, quote, the party proves nothing. This chamber has heard testimony that cadres at all levels used the label Ankar opportunistically to exercise their own petty authority. Pin's use of the phrase the party, unquote, does not mean anything literal, including that he was implementing an order from a superior. The document also clearly shows that whoever did decide to execute these 17 people, if indeed someone did, it was not because of their military position. The document specifically states that the alleged victims were, quote, examined, unquote, before a decision to execute them was made. Now, if a policy to execute all soldiers or all officers existed, there would be no need to examine any of them. Next to certain names, there are additional indications that each person's loyalty was assessed. For instance, next to number 14, Yem Sai, the document states the following, and I quote, "He is a former teacher who was a traitor when he was a teacher. In his biography, he criticizes us very strongly, using psychological warfare. His responses show absolute support for the Republic regime and opposition to the revolution." And there the order also lists two other senior military officers and a sub-district chief, noting and I quote, "Please keep for examination the following named persons." Now that alone also proves that even senior military officers were apparently not executed as a matter of policy. The second document is a 21 May 1976 news report from Agence France Presse suggesting that 54 former generals were executed shortly after 17 April 1975. In general, Mr. President, the prosecution's continued reliance on news sources should again be an indicator to the Chamber of the overall weakness of their evidence. But this document is especially unreliable and should be disregarded completely. Neither the journalist nor the unnamed quote-unquote resistance spokesman who acts as the sole source is known. Even the description of a source as resistance spokesman is confusing. Resistance to whom? A resistance faction against Pol Pot? And if so, isn't the claim transparent anti-Khmer Rouge propaganda? But the article is even more unreliable because on the substance it makes no sense. It claims that the list of generals was, and I quote, sent to several Western governments. Now, why would the CPK execute 54 people and then announce to the world that they had done it? And if they did want to announce it to the world, why would they quietly send the message to Western governments and not bluster about it? And if it was disclosed to several governments, why isn't there any evidence from any other source aside from this single news report from a single journalist? And why did the CPK suddenly decide to reveal these executions 13 months after they happened? Why did they draw up a list in December 75, 7 months after it happened? None of this, Mr. President, makes any sense. Other evidence relied upon by the co-prosecutors is completely irrelevant. Co-prosecutors say that according to Steve Hedder, new people were required to register their names during the evacuation of Phnom Penh. Notably absent is any mention of either executions or of Lon Nol soldiers. The co-prosecutors also claim that Khmer Republic prisoners were executed at S21. Yet, as we showed in our brief, and also in our prior submissions before this chamber, there is not a shred of evidence that even a single person was detained at S21 because they had formerly been a Lon Nol soldier. It was inevitable that some people detained at S21 would turn out to have been former soldiers, just as S21 detainees had done a variety of things prior to 1975. And again, we would remind the Chamber, only 2% of the alleged S21 population is alleged to have been formally affiliated with the Khmer Republic. And most of these people were detained beginning in March 1976. At most, a few dozen Lon Nol soldiers were detained at S21 in 1975. But this disproves the prosecutor's contention that Lon Nol soldiers were executed in general. The co-prosecutors claim that according to the minutes of a military meeting in September 1976, Son Sen instructed troops that, and I quote, "the soldier elements must be rounded up," unquote. Yet it is apparent in the document relied upon that Son Sen is not referring to former Khmer Republic soldiers, but to a group of RAC soldiers who sought to defect from the CPK. The document, in any event, is dated 18 months after the events at Tu Po Tre. Mr. President, Your Honours, in summary, the co-prosecutors are unable to show that anyone in the party centre intended the execution of any Lon Nol soldiers and officials. They are unable to show that executions happened in any consistent pattern across the country. They are accordingly unable to show that the CPK party centre at any time adopted a policy concerning or intended the systematic execution of Lon Nol soldiers or officials of any rank. Even more apparent, however, is that if any policy to execute Lon Nol soldiers and officials ever did exist, it could only have been severely limited in both time and scope. In particular, even if the Chamber 1 disregards the direct evidence that no policy to execute Lon Nol soldiers and officials existed, 2 disregards the fact that no systematic pattern can be deduced from the evidence, and 3 accepts without question the limited evidence of a policy which does exist, it would still be required to hold that there were 2 significant limitations on the scope of that policy. First, the evidence manifestly fails to establish that any policy to execute Lon Nol soldiers and officials could have existed in April 1975. Instead, the evidence the co-prosecutors themselves rely on demonstrates no policy could have existed prior to May 1975, at the earliest. Second, the very limited evidence of CPK policy that does exist consistently and without exception concerns only high-ranking military officers and the highest-ranking civil servant. There is not a shred, not an ounce of evidence that the CPK ever intended to execute ordinary soldiers or civilian authorities. Mr. President, I will first consider the question of the timing of the alleged CPK policy. The evidence which the co-prosecutors themselves rely on contains numerous inconsistencies with regard to the point at which the supposed CPK policy to execute Lon Nol soldiers and officials came into effect. Nor have they provided any basis on which to resolve those inconsistencies. They have accordingly failed to articulate any coherent theory of their case. The evidence as a whole, including that which the co-prosecutors conveniently decide not to consider, establishes that no policy could have come into effect earlier than May 1975. On the one hand, the co-prosecutors assert that the policy of executing Lon Nol soldiers and officials came into effect on or before 17 April 75. They explicitly and vigorously argued on Thursday and Friday of last week that a policy of systematically executing Lon Nol soldiers and officials existed long before April 1975. They similarly argue that Long Beret and other top officials of the Khmer Republic were detained at the Ministry of Information and executed immediately thereafter at the Cercle Sportif on 17 April 1975. The co-prosecutors explicitly described this incident as evidence of the policy which was subsequently implemented at Tu Po Tre. However, the co-prosecutors also cite Ieng Sari's statement that the CPK's decision to execute leaders of the former regime came a few days after April 17, on around April 20. Our position is clear. This statement is not reliable. Ieng Sary explicitly told Steve Hedder that, and I quote, "On this, I knew nothing at all," unquote. But in relying on this statement, the co-prosecutors failed to resolve an obvious inconsistency with their own position. Did a policy come into effect long before 17 April 75, or did it manifest for the first time on 20 April 1975? Next, the co-prosecutors cite Steve Hedder's testimony that K. Pauk told him, quote, that as secretary of the CPK North, later Central, Zone Committee, he had implemented a CPK policy of killing Khmer Republic officials, unquote. Steve Hedder then explained that Pauk was, and I quote, from around May 75, secretary of the North Zone, unquote. Thus, even if Pauk's testimony were accepted at face value, it would establish that a policy of executing Khmer Republic officers and officials began sometime after May 1975. But, Mr. President, we note that Pauk was the chief military commander in the North Zone from long before May 1975. He would surely have been involved in the CPK's supposed policy in that capacity had one existed. The co-prosecutors do not resolve this inconsistency either. Indeed, they do not recognize or acknowledge it. The co-prosecutors' own submissions therefore suggest the existence of at least 3 different theories concerning the moment at which a policy of executing Lon Nol soldiers and officials first came into effect. They do not engage the details of these statements. They do not tell us with any specificity, when, how, and under what circumstances the senior leaders came together and agreed to execute all former Lon Nol soldiers and officials. They do not give us any coherent theory of the case. Instead, they quote snippets of these statements, stringing them together as generalized support for an abstract concept which they call a policy to execute Lon Nol soldiers and officials. Other evidence on the case file, not cited by the co-prosecutors, however, resolves these inconsistencies. That evidence establishes without any serious doubt that no policy of executing Lon Nol soldiers could have existed prior to May 1975. That evidence is in the form of the statements taken by Ben Keenan with regard to the 20 May 1975 conference in Phnom Penh. That is that same conference described by Heng Samrin in the statement I referred to at the beginning of my remarks. The evidence of this meeting is the most concrete indication on record of any Standing Committee agreement with regard to the treatment of Khmer Republic officials. It was a meeting of zone-based officials in Phnom Penh at which party policy was disseminated to zone-level officials for the first time following liberation. And although differing accounts of that conference exist, the parties agree that Khmer Republic soldiers and officials were a subject of discussion. As we have already seen, Heng Samrin has told Ben Keenan that Nguyen Chia specifically instructed cadres at that meeting that soldiers and officials of the Khmer Republic were not to be killed. Chia Sim has a different account of the substance of that policy, yet his statement is consistent with Heng Samrin's in a key respect. that CPK policy concerning the treatment of Khmer Republic soldiers and officials was discussed. In oral submissions on 13 June 2013, the co-prosecutors encouraged the Chamber to refer to Chia Sim's account of that meeting. The co-prosecutors therefore apparently believe that Chia Sim's statement is reliable in this regard and that a policy concerning Lon Nol soldiers and officials was communicated at this conference. But that raises a critical question. If an agreement with zone officials concerning the treatment of Lon Nol soldiers already existed in April 1975, why would it have been necessary to communicate it in May 1975? The answer is apparent. It would not have been. It is crucial to recall that Heng Samrin and Chia Sim were both high-ranking members of the East Zone Army. As a deputy division commander, Heng Samrin was only 2 rungs below Sao Pim in the hierarchy. It's almost certain that if Sao Pim had agreed with Nuon Chea on a policy of executing Lon Nol soldiers and officials existed in the East Zone in April 1975, both Heng Samrin and Chia Sim would have been informed. At the minimum, they would have learned of it later. Yet it is apparent from their statements that both men were informed of the CPK's policy in relation to Lon Nol soldiers and officials for the first time on 20 May 1975. And neither Heng Samrin nor Chia Sim were reluctant in their interviews to describe intimate and even self-incriminating information. Both supposedly told Kiernan of the policy concerning Lon Nol soldiers and officials that was communicated in May 1975. There is no reason at all why they would have spoken of the policy in May 1975, but then at the same time failed to mention that it already existed on 17 April 1975. Moving on from the timing of the alleged CPK policy, it is equally clear that its scope, if at all, was limited only to senior military officers and high-ranking civilian officials. No one in the party center ever intended the execution of low-ranking soldiers or ordinary civilians. Even the co-prosecutor's own evidence, although unreliable on its face, consistently concerns only high-ranking officers and the highest-ranking civil servants. There is not a single testimonial account to the contrary. The co-prosecutors repeatedly cite Ieng Saree's statement to Steve Hedder in regard to the supposed policy of executing Lon Nol soldiers. Yet the policy Ieng Saree purports to describe is limited only to high-ranking members of the former government. Now, the relevant exchange between him and Steve Hedder is as follows, and I quote, Steve Hedder first. The documentation does make it clear that those to be executed included military officers, senior officials, secret agents, and a number of other categories. But there is nothing about ordinary soldiers and lower-ranking civil servants, like school teachers. End of quote of Steve Hedder. Ieng Saree answers the question, there is nothing. There is nothing. Chia Sim's summary of the 20 May 1975 meeting concerns even higher-ranking officials. According to Ben Kiernan's notes of his interview with Chia Sim, one of the policies established at the May 1975 meeting was to, and I quote, kill leaders of the LN government, unquote. Heng Samrin's account of the 20 May 1975 meeting also concerns, quote, the Lon Nol leaders, end of quote. And even Philip Short, on whom the co-prosecutors rely repeatedly in relation to this supposed policy agrees that it encompassed only, and I quote, Lon Nol soldiers above a certain level and high-ranking officials, end of quote. Mr. President, Your Honour, this concludes my discussion of the alleged and non-existent CPK policy to execute Lon Nol soldiers and officials. We have established that no policy of targeting Lon Nol soldiers and officials existed at any point within the CPK party centre. However, we have also established that if such a policy ever did exist, it could only have come into effect in May 1975, and it could only have targeted senior military officers and high-ranking civilian officials. Your Honours, I will now turn to the crime-based evidence as to portray. Our analysis will have three components. First, I will establish that notwithstanding the co-prosecutor's insinuations to the contrary, the evidence which concerns to portray is limited and inconsistent. The evidence before this chamber, which consists of no physical evidence, no bodies of any victims, no names of any victims, no eyewitness testimony of any killings, virtually no eyewitness testimony of any substantial portion of the alleged transaction which led to the alleged killings, is manifestly insufficient to support a conviction beyond a reasonable doubt. Secondly, Your Honours, I will establish that even if the Chamber were to conclude, beyond a reasonable doubt, that the attendees at the Pursat Provincial Town Hall meeting were transported to Portray and executed, it would be unable to hold Nuon Chea criminally responsible for those executions. And the reasons will by now be apparent. The CPK never adopted a policy of executing Lon Nol soldiers and officials. And if it had adopted such a policy, it would undeniably have been limited, both in time and in scope, such that it could not have encompassed the crimes allegedly committed at Portray. Third and finally, I will establish that lower-level zone-based officials had substantial motive and opportunity to commit the crimes alleged at Portray. Accordingly, if the Chamber were to conclude that executions did take place at Portray, the only reasonable conclusion would be that those crimes were committed by lower-level authorities without the knowledge, intent, or assistance of the party centre. I will now turn to the reliability of the evidence on the case file which concerns Portray. In assessing this evidence, the crucial question to consider is whether the evidence is sufficient to establish that the execution of Lon Nol soldiers and officials at Portray actually occurred. To determine this very point, to assess whether the Portray executions allegations were true, the investigating judges conducted a site examination at Portray. Investigators traveled to Pursat. They went out into the field to the alleged site of the Portray executions, and they carried out a thorough investigation. And from this investigation, they produced a site identification report detailing their findings. What were those findings? What did this investigation, conducted over 30 years after the alleged executions, produce? The report states that the investigators found the four following items. 1. Fragments and debris of bones which, quote, give the impression of being, unquote, human remains. 2. Fired shell case and 1 bullet head. 3. Several metal artifacts such as belt buckle and zippers. And 4. A noticeable presence of cloth mixed into soil. Now, as the Chamber is aware, I'm not a lawyer. I'm a lawyer, sorry, not an investigator. Excuse me. But I know that if I see items like a belt buckle or a zipper laying on the ground or shreds of cloth mixed into the dirt, I don't immediately assume it is direct evidence of a 30-year-old mass execution. When I walk through an area presently used for farming that was previously an army base, and I find the casing of a bullet laying in the grass or a bone fragment, I do not conclude that I have found definite proof of murder. What might be reliable evidence to establish proof beyond a reasonable doubt of a mass execution? A gravesite, a human corpse, remains that have been tested by experts and have, at a bare minimum, Your Honours, established to be human. Was a single mass gravesite discovered? The answer is no. Were sites thought to be graves ever unearthed or examined? The answer is no. Was a single corpse or skeleton located? Again, the answer is no. Were bone fragments tested? No. Do we even know if those bone fragments were human? The answer again is no. Now, without physical evidence of a single murder at Tulpo-Tre, how could there be proof beyond a reasonable doubt of these alleged executions? The answer is there could not. And it seems, Mr. President, Your Honours, that the investigators agree with us. They note in their report the possibility that the items found, including the bullet and shell casings, could have come either from the heavy combat that occurred there, or the fact that the area had been the former location of a Lon Nol army camp. Most importantly, the investigators do not report that the Tulpo-Tre site is a crime site. They do not even conclude that it is a possible crime site. What they report is that there are, quote-unquote, indications that it could be, quote-unquote, a possible crime site. Now, in a criminal trial, an indication of a possibility can obviously never be enough. Now, the poor quality of the evidence in regards to Tulpo-Tre extends to the witness statements on the case file. Witnesses TCW 699, E3/5500, TCW 644, and E3/5234 all gave statements to the investigating judges in regards to Tulpo-Tre. These statements were relied on in the closing order and have been admitted against our client as evidence in this trial. Yet the evidence in those statements is neither compelling nor reliable. Not one of these witnesses was an eyewitness to the alleged killings. Not one could provide the name or details of even one alleged victim. Not one could provide any details regarding the alleged crime scene. Both E3/5500 and E3/5234 never saw corpses. although the statements of TCW 699 and TCW 644 suggest they later saw bodies, neither provides any reliable evidence in that regard, including the details of what they saw, or in the case of TCW 644, even the date on which they saw it. Instead, TCW 699 makes the questionable claim that he saw bodies 11 years after the alleged killings. And TCW 644 tells us nothing at all. The Nuajia defense sought many months ago to have these witnesses summoned to appear before the chamber. All of these questions could have been answered. All of these allegations could have been subject to scrutiny in an open court. All 4 witnesses could have been heard within a week. Despite the fact that Tulpo Tray is one of only 3 crime sites at issue, and these statements constitute the sum total of the testimonial evidence, this chamber declined. And we would argue that minimal fair trial guarantees require that these statements now be disregarded and accorded 0 probative value. The unreliability of the evidence extends also to the only 3 witnesses to appear before the chamber. As I will highlight in more detail momentarily, the evidence given by Limsat, Ungchat, and Sumalat proved confused and inconsistent, and repeatedly contradicted the evidence given before the investigating judges. The only other evidence concerning Tulpo Tray is in the video One Day at Portray, co-produced and directed by Rob Lemkin and Ted Sambat. The prosecution asked the chamber to find the key individuals who appear in the film and summons them to testify before the chamber. These individuals could not be located. We don't know why. The court was in possession of their pictures and was aware of their locations. But in any event, the failure to locate them significantly reduces the probative value of the evidence. The prosecution presumably recognizes this as such, which is why they sought the appearance of the witnesses to begin with. The problems with the evidence are especially apparent in relation to the number of people allegedly killed at Tulpo Tray. A variety of estimates exists on the case file, each one based on a witness' offhand guess, based on a glance in the general direction of a group of people or alleged corpses. One witness sees 200 people in the meeting, another sees 1,000 people in the ditch, a third sees 5,000 in a pond, and a fourth sees 50 on a truck. Now, these estimates are inherently unreliable by virtue of the methodology, or lack thereof, employed by the witnesses. They are rendered useless by the wide variations from one estimate to the next. The investigating judge's total failure to verify any of them, and the fact that they are the product of 35-year-old memories. Mr. President, Your Honours, before I continue on Tulpo Tray, I feel the need to make a small detour here to comment the quality of the evidence on the case file in regard to death tolls in general. Tulpo Tray is just one example. Another one concerns the estimates as to the number of deaths allegedly caused by the evacuation of Phnom Penh. Now, the principal estimate comes from Ben Keenan's highly questionable approximations. Kiernan asked 36 out of 100 individuals how many members of their family had been lost during the evacuation. These 36 reported a total loss of 2 relatives each. Kiernan applied this percentage to the population of Phnom Penh as a whole, foolishly deducing that 10,000 people must have died during the evacuation. Now, Mr. President, Your Honor, such calculations are grossly simplistic, based on flawed methodology and entitled to no weight whatsoever. Using Kiernan's baseless estimate of 10,000 dead, Philip Short took a different writer's equally baseless estimate of 35,000 dead, averaged the sums, and concluded that 20,000 people died. This calculation, Mr. President, would not pass muster in an introductory research methodology class. Once again, these examples highlight the fact these proceedings have prioritized convenience and expediency at the expense of accuracy and of credibility. The figures presented as the death tolls from these events are unsubstantiated and misleading, and they should not be recognized by the Chamber as anything other than gross exaggerations based on flawed evidence. Now, Mr. President, returning now to Tu Po Tray. The question remains, has the OCP, have the prosecutors proven beyond a reasonable doubt that the execution of Lon Nol soldiers and officials at Tu Po Tray actually took place? The answer is no. And even if we were to accept that there are indications of executions, indications are simply not enough. The evidence is not strong enough to prove that these executions took place beyond a reasonable doubt. Mr. President, Your Honours, I have now shown you that there was no systematic CPK policy to execute Lon Nol soldiers and officials. And I have shown that the crime-based evidence concerning Tu Po Tray is inconsistent and fails to prove beyond a reasonable doubt that the attendees at the Pursa provincial town hall were executed. Each of these conclusions is by itself sufficient to establish that our client is not guilty of the crimes charged in connection with Tu Po Tray. It is accordingly clear that he may not be convicted. This, however, is not the end. Because even if both of these suppositions are wrong, Nguyen Chia still cannot be convicted. Even if the CPK Party Center did adopt a policy of executing Lon Nol soldiers and officials, and the alleged executions at Tu Po Tray took place, it would still be impossible to convict Nguyen Chia. We have already stated the reasons. No agreement with zone-level officials to execute Lon Nol soldiers and officials could have existed before May 75. And no policy to execute ordinary soldiers and civilians existed at any time. Yet the events at Tu Po Tray took place in April 1975, and the alleged victims at Tu Po Tray were ordinary soldiers and civilians. Mr. President, I would like to refer the Chamber to the co-prosecutor's brief at paragraph 306. In that paragraph, the co-prosecutors argue as follows, and I quote, "Although the trial chamber heard evidence of the general identity of those killed at Tu Po Tray, the individual identity of most of those killed is not known. It is clear, however, that those killed were members of the former Khmer Republic, many being military and civilian personnel." End of quote. The co-prosecutor's failure to specify the identity of those allegedly killed at Tu Po Tray beyond the very generic phrase quote-unquote members of the former Khmer Republic is fatal to their argument. By itself, this paragraph constitutes an admission requiring dismissal of all charges concerning Tu Po Tray. And in fact, as our brief shows clearly, the evidence proves unequivocally that the alleged victims at Tu Po Tray were overwhelmingly ordinary civilians and low-ranking soldiers. First witness to appear before the chamber in relation to Tu Po Tray was, I just mentioned his name, Ung Chat. Now, Ung Chat was a CPK soldier who stood guard outside the provincial town hall meeting. He claims to have recognized a single mid-ranking military officer named Pel at the meeting. Other than Pel, Mr. Ung, quote, did not recognize anyone. I did not know any other people, unquote. He also explained that the statement contained in his written record of interview, which indicated that, quote, generals, unquote, were in attendance, was a suggestion put to him by the investigators. He personally could only, quote, presume, unquote, that people attended the meeting, quote, would be, unquote, those of senior rank. The second witness to appear before the chamber was Lim Sat. Lim Sat was a CPK soldier who stood guard on the road between Pursat and Tu Po Tray. Lim Sat testified that he merely witnessed trucks drive past from the side of the road. He was therefore unable to testify as to the identity or seniority of any of the alleged victims. The third and final witness to testify to events at Tu Po Tray was Sum Alat. He was a 21-year-old ordinary Lon Nol soldier who claims to have attended the meeting at the town hall. After stating initially that he personally knew 10 or 20 senior officers at the town hall meeting, our repeated efforts on cross-examination to obtain one single name of a ranking officer were rebuffed in a series of evasive and non-committal responses. Now, eventually, this witness produced two names: Prum Li Hun, the Pursat provincial governor, and a second person whom the witness called Nu Sun and described as the governor of that province. Now, that answer is, of course, internally inconsistent, as it was Prum Li Hun and not Nu Sun who was the governor of Pursat. Most important, however, is his claim, Sumalat's claim, that he himself participated in that meeting. Either Sum was present at the meeting, establishing that it was not a gathering of senior officers, or he was not, and his testimony is not credible. The limited evidence, Mr. President, that does exist concerning the composition of the meeting establishes that of ordinary soldiers, students, and low-level officials were apparently present. Sumalat testified that 60% of the attendees were civilians, yet no witness identifies the presence of a single senior civilian authority other than the provincial governor, Prum Li Hun. Sumalat specifically added that ordinary civilians and students were in attendance, and Ung Chat indicates that all of the attendees were wearing civilian clothes. To the extent that military personnel were present, the evidence shows that at a minimum, the large majority consisted of ordinary soldiers. Both Ung Chat and Sumalat testified that soldiers from the Tu Po Tray fort attended the meeting as a group. And estimates of the number of soldiers stationed at the Tu Po fort range from 30 to 200. And Sumalat furthermore stated specifically that ordinary soldiers were present. Now, Mr. President, as we have already observed, the essential importance of this distinction between top-level Khmer Republic authorities and low-level soldiers and officials came last week from an unexpected source, the prosecution. Last Friday, the co-prosecutors played for the chamber a videotaped statement by our client, Nguyen Chia. And in that statement, Nguyen Chia concedes having known about the execution of the so-called 7 super traitors, the senior-most leaders of the Khmer Republic. The co-prosecutors claim that this statement was made without duress. They say that Nguyen Chia's statement is highly reliable. They claim that it constitutes an admission of our client's intent with regard to the representatives of the Khmer Republic. Yet, Mr. President, Your Honours, as we showed you on Tuesday, in the exact same sequence, Nguyen Chia denies having had any knowledge or intention in relation to the execution of lower-ranking Khmer Republic soldiers and officials. He denied having any knowledge of the events at Tu Po Tre. We agree that these statements are indeed highly reliable. They exculpate Nguyen Chia. Mr. President, this very nearly concludes our discussion of Tu Po Tre. Only one significant question remains. If Nguyen Chia is not responsible for these crimes, then who is? Nguyen Chia does not know the answer to this question. He had never heard of Tu Po Tre before this trial and does not know what happened there. He assumes that if crimes were committed, they must have been orchestrated either by local cadres in Pursat or by Northwest Zone Secretary Ru Nim. Either one would have had the motive and the opportunity to do so. The possibility that Ru Nim is responsible is heightened substantially by the extent of the authority generally exercised by powerful zone leaders within their territory. As we indicated on Tuesday, Nguyen Chia is certain that the party center faced great opposition from Ru Nim, who was aligned, possibly from much earlier than our client originally suspected, with Sao Pim against him and Pol Pot. Ros Nim was therefore more than a mere autonomous actor, although he was certainly that. He was an autonomous actor with a direct interest in acting contrary to CPK policy. He was an autonomous actor with a direct interest in misrepresenting CPK policy to the inhabitants of his zone, with a direct interest in provoking opposition to Pol Pot. Even during Democratic Kampuchea, the information to which Nguyen Chia was privy suggested that conditions in the Northwest Zone may have been worse than those across the rest of Cambodia. The research of numerous contemporary scholars showing that conditions were in fact especially bad and executions particularly widespread do not surprise him. Indeed, they confirm Nguyen Chia's long-held suspicions about Ros Nim. In spite of all of this evidence, the co-prosecutors persist in their belief in a simplistic, easy-to-follow story about democratic Kampuchea. Despite all of these uncertainties, they assert at paragraph 196 of their brief that there can be, quote, no doubt that every single killing of Lon Nol soldiers and officials on or around 17 April was, quote, carried out in pursuance of an order from the party center. Now that claim is of great significance because it essentially confirms Nuon Chia's assertion that the alleged victims at Tulpo Tray could only have been ordinary soldiers and civilians. The co-prosecutors do not argue that the alleged victims at Tulpo Tray were officers and high-ranking officials. They very nearly concede that they were not. Instead, the co-prosecutor's position is that it does not matter who the victims were. The co-prosecutor's position is that if a Lon Nol soldier was killed on or around 17 April 1975, Nuon Chia must have been responsible. Now, Mr. President, that claim is deeply inconsistent with the evidence. It is inconsistent with the widespread evidence that vast numbers of killings in democratic Kampuchea occurred without the consent of the party center. That zone leaders exercised substantial autonomy and discretion. That most killings in democratic Kampuchea, even according to David Chandler and Steve Hedder, occurred without the consent of the party center. The only evidence they cite in support of this extraordinary conclusion is, surprise, surprise, Philip Short. Mr. President, Your Honors, we think that a better source than Philip Short is Ieng Sary. Ieng Sary says, and I quote, even Pol Pot and Nuon Chia, when they were in Sao Pim's zone, the East Zone, they were afraid of Tapim. I went with them once, and I knew that and saw that. That is, Pol Pot himself did not dare go down below. He was afraid of Tapim. So, in that zone, if Sao Pim wanted to kill and wanted to do something, it was not necessary for him to ask upper echelon. The organization was like that. Each zone was independent, almost what would be called kill as you please, do as you please. End of quote. Mr. President, Your Honors, this excerpt, I think, speaks for itself. This concludes, Your Honors, our discussion of Tulpo Tray. We submit that on any standard of proof, it is apparent that our client, Nuon Chia, is not criminally responsible for the events at Tulpo Tray. The co-prosecutors claim that they have established Nuon Chia's responsibility beyond a reasonable doubt without any direct evidence is nothing short of absurd.
The President, thank you, Counsel. The time is now appropriate for lunch adjournment. The Chamber adjourns now and resume at 1:30 this afternoon. This is the information for members of the public and also the notice to parties and support staff. Security guards are instructed to bring Mr. Khieu Sampon to the holding cell downstairs and have him return to this courtroom before 1:30. The court is now adjourned.